And welcome back. Now, we are about to have that conversation about not paying child maintenance and how that could now result in a guilty party being blacklisted and unable to get credit. The Justice Department has signed a Memorandum of Understanding with the Social Justice Foundation and the Consumer Profile Bureau for Maintenance Online Listing Project. Now, we understand the MOU will ensure that the details of defaulting individuals are actually handed over to credit bureaus and other credit providers. But for more on this initiative, we are joined on the line now by Director of Maintenance Services at the Department of Justice and Constitutional Development, Kamogelo Lekubu-Wilderson. Kamogelo, thanks so much for speaking to us. Welcome to Morning Live.
Good morning, Sakina. Good morning, Leanne.
So firstly, if you could please explain to us how this Memorandum of Understanding was arrived upon and reached the point of being signed between the department and other partners on a practical level.
Thank you very much for this opportunity. I think the obligation on the Department of Justice has been long-standing as a result of the amendment of the Maintenance Act in 2015. This amendment brought into, basically gave the department an obligation to ensure that once an enforcement order is issued, our officials at court must forward the name and details of the persons against whom the enforcement order has been granted to service providers or credit providers or credit bureaus. So this provision basically came into effect in 2019, but because of lack of capacity within the department, it was delayed. So as we established this directorate, it became very critical that we start on ensuring that we implement this obligation because there are high levels of lack of compliance with initial maintenance orders. So it is this particular challenge that we have, number one. Secondly, in South Africa, we've got more than 7,000 credit providers and more than 49 credit bureaus. So it would be very difficult for court officials to know which credit bureau or service provider to send these details to. So as we did a national maintenance working session in reflecting on the key issues that are facing us in terms of enforcing this obligation, we had the opportunity of inviting Credit Profile Bureau as well as Social Justice Foundation to just tell us how they actually understand this provision and how we can work together. So as a result, we actually formed a partnership that will help us streamline the forwarding of the details.
Just a few questions.
To avoid any risk that could occur, it is quite critical that we mainstream or we streamline how the department forwards this data because it's sensitive data which relates to really personal profiles of people.
Yeah. Kamogelo?
So this is how we came to this agreement.
If I may just ask a few quick questions because we have some time pressure. So firstly, what is the rate of defaulting on maintenance by parents? And I say parents, both fathers and mothers. And are you able to give us that breakdown in terms of mothers and fathers who are defaulting?
Unfortunately, the way the legislation is structured, it is structured such that once an initial maintenance order is granted and there is default, the beneficiary must come to court to apply for enforcement order. I will give you the statistics of the enforcement orders that are issued on an annual basis. These are between 2,500 and 3,000 per annum. So you can imagine there could be a whole lot of other mothers or beneficiaries out there who are just not coming to court to enforce the orders. So I would like to press it upon or put an impression to the public that we have additional measures to make sure that these initial maintenance orders are enforced through forwarding the details of defaulters to the credit bureau so that they do not deplete or dissipate their financial needs to the detriment of the maintenance order.
So I would imagine there would be quite a few repercussions that stem from this. And before we even talk about implementing that whole blacklisting, you did touch on that. But just in terms of the enforcement orders, how do you get to the point of the enforcement order being issued, one? And two, is this not going to open a can of worms as far as paternity, the questioning of paternity of a lot of these cases? Because I would imagine people now saying that, I first need to be sure that this is in fact my child before we can proceed on anything else.
Yes, Sakina, let me mention that what I said earlier on is that before we even come to the point of implementing Section 26(2)(a), which asks us to forward the defaulters' details, we have an initial maintenance order that is granted. Before you even go to court, we ask those pertinent questions. The parties are required to voice their objections, and if they need a DNA test, we will question whether you can afford the DNA test as the father who's disputing, or whether both parties can afford. And if they cannot afford, the court will pay for their DNA test. So even before you agree to the order, those issues will have been cleared at the informal inquiry level. So by the time we come to the enforcement order, the paternity issues normally are clear. We have one of few cases where the father agrees to pay maintenance, and when we come to enforcement order, they raise paternity as a technicality. Justice is justice. We will afford them the opportunity to go and do the DNA, even at the enforcement order application stage. And often, those DNA tests, often they come positive. And as a result, we go ahead to enforce the order. Because the Section 26 by itself is a measure to enable us to enforce the initial order. So where there are areas, we will recoup areas, as well as in circumstances where we can even say, for instance, if the father is working, we will say, pay the areas, as well as now we garnish you because you are unable to handle your matters. Then the court takes over the responsibility in the best interest of the child for future maintenance of the child. So we will garnish you. In instances where you are an informal business person, or you are in business, we will use other measures such as attaching property and attaching your pension if we are forced to come to that point. But then what it means is that even once the court has made that order, we still apply a punitive measure by forwarding your name to the credit bureau until you clear the area.
Well, unfortunately, we're out of time, but that's where we have to leave it. Very interesting developments here. That was Kamogelo Lekubu-Wilderson, Director of Maintenance Services at the Department of Justice and Constitutional Development, speaking to us about now the latest blacklisting of parents who default on child maintenance payments.
Tough conversation, it really is. I'd love to know what viewers feel, but maybe we can pose that to you on another day.